Texas traffic stop backfires. Sheriff stops black judge. Faces $100 million lawsuit. The flashing red and blue lights cut through the late afternoon haze like a predator's eyes locking onto prey. Judge Aisha Montgomery, one of the most respected federal judges in the Southern District of Texas, glanced in her rearview mirror and felt a familiar knot tighten in her stomach. She wasn't speeding. She hadn't run a red light. Her sleek black Mercedes, earned through 2 decades of unyielding work in courtrooms where justice often felt like a war, was traveling exactly 2 miles from her home in a quiet Houston suburb. But on that ordinary Thursday in October, Sheriff Harlan Hank Whitaker of rural Caldwell County decided this luxury car, driven by a black woman in a tailored suit, simply didn't belong on his stretch of highway. He hit the sirens, pulled her over, and stepped out with the swagger of a man who believed the badge made him untouchable. What Whitaker didn't know, what no one in his department had bothered to teach him, was that the woman he was about to humiliate wasn't just any driver. She was the judge who had already sent 3 of his deputies to federal prison for corruption. And this single, arrogant mistake would unravel a web of misconduct stretching back 15 years, cost the county a staggering $100 million in damages and settlements, end Whitaker's career in disgrace, and force a reckoning that echoed across the state. The stop Aisha Montgomery had spent the morning presiding over a high-profile racketeering case involving a cartel-linked smuggling ring. Her gavel had fallen hard, denying bail to the lead defendant and setting a trial date that promised to make headlines. Exhausted but satisfied, she loosened her silk scarf as she merged onto the rural highway that cut through rolling fields and scattered oil rigs. The sun hung low, painting the sky in streaks of orange and gold. At 4:12 p.m., the patrol SUV appeared in her mirror, closing fast. Aisha signaled, eased onto the shoulder, and killed the engine. She placed both hands on the wheel at 10 and 2, old habits from law school lectures about traffic stops and survival. Her heart rate stayed steady. She'd been pulled over before. Profiling wasn't new to her. But she had never been pulled over here, in Whitaker's jurisdiction, where the sheriff's department had a reputation for being old school in the worst possible way. Whitaker approached slowly, one hand resting on his holster, the other holding a flashlight even though daylight still lingered. He was a big man, late 50s, with a weathered face and a mustache that looked like it belonged in a 1980s Western. His badge gleamed under the sun. "License and registration," he barked, not bothering with pleasantries. Aisha reached slowly for her glove compartment, narrating every move. "I'm reaching for my documents, officer. My license is in my purse on the passenger seat." Whitaker's eyes narrowed at the word officer. Most people called him sheriff or sir. He leaned in closer, peering through the tinted window. "Step out of the vehicle, ma'am." Aisha's eyebrow arched. "May I ask the reason for the stop, sheriff?" "Suspicious vehicle. Luxury car like this, folks don't usually drive them around here unless they're up to something. Plus, your tags look off." Aisha knew her tags were current. She'd renewed them personally 3 weeks earlier. But she complied, stepping out on her heels, briefcase in hand. She stood tall, 5'9" in flats, her presence commanding even on the dusty shoulder. Whitaker ran her plates while she waited. The radio crackled. Clean. No warrants. No stolen vehicle report. Nothing. He wasn't satisfied. "Pop the trunk," he ordered. "Sheriff, you have no probable cause for a search," Aisha said calmly, voice level. "I've committed no traffic violation. This stop is pretextual at best." Whitaker smirked. "Pretextual? Fancy word for a lady in a fancy car. Open it, or I'll do it myself." Aisha met his gaze. "I am Judge Aisha Montgomery, United States District Court, Southern District of Texas. I suggest you radio your supervisor and explain why you're detaining a federal judge without cause." For a split second, something flickered in Whitaker's eyes, recognition, maybe fear. But pride won out. "Judge or not, you're in my county now," he sneered. "Hands on the hood." He reached for her arm. That was the moment everything changed. Aisha didn't resist, but she didn't move either. Instead, she spoke words that would later be played in courtrooms and newsrooms across the country. Sheriff Whitaker, I am recording this interaction. Body camera or not, my dash cam is active, and I have already alerted my chambers that I was being pulled over. You are now on notice. Whitaker froze. He glanced at the Mercedes, noticing for the first time the small, discreet camera mounted behind the windshield, one of those high-end systems judges sometimes used for security after receiving threats. It was blinking red. The sheriff's face flushed redder than the lights on his cruiser. He stepped back, hand dropping from his weapon. Look, lady, Your Honor, this is just routine. Routine doesn't include false pretext, illegal detention, or attempted unlawful search, Aisha replied. You've violated my Fourth Amendment rights, and you've done it on camera. Step aside. I'm leaving. Whitaker stammered, suddenly aware of passing cars slowing to gawk, phones already out. He tried to salvage it. You can go. But watch yourself around here. Aisha slid back into her car, started the engine, and drove away, calm, composed, furious. By the time she reached home 20 minutes later, the video from her dash cam had been uploaded to a secure cloud. She called her attorney, then the DOJ Civil Rights Division. Then she sat down with a glass of red wine and began drafting the complaint that would become one of the largest civil rights lawsuits in Texas history. Little did Whitaker know, this wasn't just about one bad stop. It was the spark that would ignite a firestorm, exposing kickbacks, planted evidence, and a shadow network of corruption that had protected him and his deputies for far too long. The backfire had begun. Aisha Montgomery didn't wait until morning. By 9:17 p.m. that same Thursday, 3 separate emails had already left her secure server to her personal civil rights attorney, Maya Ellison, former DOJ prosecutor. Feared even by insurance company defense teams, full dashcam footage, GPS log, time-stamped photographs of the patrol SUV's license plate, and a bullet point chronology of the stop. To the Chief Judge of the Southern District of Texas, a personal friend since their days clerking together, a concise, professional memo titled Potential Immediate Threat to Judicial Safety and Independence. Request for coordination with Marshal's Service. To the Civil Rights Division of the U.S. Department of Justice, direct to the section chief she had worked with on 3 prior pattern or practice investigations. Subject line urgent. Color of law violation involving sitting federal judge by Caldwell County Sheriff, video evidence attached. She slept 4 hours. At 6:45 a.m. Friday, her phone vibrated with a text from Maya, already have local PI on retainer. We're pulling every traffic stop report Whitaker's department has filed in the last 36 months. Also running his financials. Give me 72 hours. By noon, the first visible ripple appeared, not in a courtroom, but on X. A passing driver who had slowed down during the stop had uploaded 32 seconds of cell phone video. The clip showed Whitaker's aggressive stance, Aisha's calm but unmistakable identification as Judge Montgomery, and the sheriff's now infamous line, "Judge or not, you are in my county now." The post was captioned simply, "TX Sheriff just tried to pull a federal judge over for driving while black." She identified herself on camera. He didn't care. This is wild. Hashtag Texas, hashtag police misconduct. It had 1,400 retweets by lunchtime. By dinner, 47,000. Caldwell County sits about 90 minutes northwest of Houston, small, mostly white, heavily Republican, oil and cattle money. Sheriff Hank Whitaker had held the office uninterrupted since 2008, running unopposed in the last 3 elections. His campaign sign still read the same slogan he'd used since his first run, back to basics, law and order. The county's 911 center started receiving calls within hours of the video going viral. Not from outraged activists in Austin or Houston, this was locals. Farmers. Retirees. A high school principal. All asking variations of the same question, is it true the sheriff pulled over Judge Montgomery? The department's public information officer, a 24-year-old deputy who also doubled as the department's social media manager, posted a terse 3-sentence statement on the official Facebook page. On October 17th, a traffic stop was conducted in accordance with department policy. No citations were issued. The matter is under internal review. That post received 812 comments in 4 hours. The top-rated one, 1.4K likes, read, "Y'all better hope that judge has a forgiving heart, because the rest of us sure don't." Meanwhile, in the high-ceiling brick courthouse on the square in Lockhart, county seat of Caldwell, 2 assistant district attorneys who had quietly disliked Whitaker for years began doing something dangerous, talking to each other. Over lukewarm coffee in the break room, ADA Lauren Payne whispered to her colleague Marcus Tate, "You remember the Garza case? 2019? The one where Whitaker swore the informant was rock solid and then the guy recanted on the stand?" Marcus nodded slowly. "And the body cam footage that mysteriously didn't exist for that traffic stop on FM 713 last summer. The one where the guy claimed his cash was taken." They looked at each other for a long beat. Lauren finally said it out loud, "If a federal judge is willing to go nuclear, maybe it's time we stop pretending we didn't see what we saw." That afternoon, Lauren Payne made a phone call she had been mentally rehearsing for 3 years. She dialed the FBI field office in San Antonio and asked for the Public Corruption Squad. Across town, in a modest ranch-style house on the edge of Luling, retired Caldwell County Deputy Ramon Alvarez opened the email his daughter had forwarded him, the viral clip of Whitaker and Judge Montgomery. Ramon had left the department in 2017 after Whitaker suggested he retire early rather than face an internal affairs complaint for refusing to sign off on a search warrant affidavit he believed contained planted information. He'd kept quiet. He had a pension to protect, kids in college. But he still had the flash drive. 11 gigabytes of personal body cam footage he had secretly copied before he left. Every stop he'd ever made after Whitaker ordered the department to stop uploading to the cloud server in 2015 for budget reasons. He'd kept it because he didn't trust anyone to delete it honestly. He stared at the screen, thumb hovering over the forward button. Then he typed one line to his daughter, "Tell your cousin at the Chronicle I'll talk." On record. But only if they can guarantee the video gets to the right people first. By Saturday morning, the Texas Tribune had published the first major story, Sheriff's Traffic Stop of Federal Judge Sparks Calls for DOJ Investigation. The article quoted 3 anonymous current deputies, 1 retired deputy, Ramon, speaking on background, and, most damaging of all, a sitting state district judge from the neighboring county who said, off the record but clearly enough to be attributable as a senior jurist familiar with Caldwell County proceedings, "Hank Whitaker has operated like this stretch of highway is his personal fiefdom for too long. If Judge Montgomery decides to press this, a lot of people are going to prison." Aisha read the article while drinking her second cup of coffee. She didn't smile. She simply opened a new document titled Montgomery vs. Whitaker et al., First Amended Complaint, and added 1 more paragraph under the heading Pattern and Practice Allegations. Then she called Maya Ellison. "How fast can we file for a temporary restraining order to preserve all evidence in the sheriff's department?" Maya laughed once, short and sharp. "Already drafted. We're just waiting on 1 more affidavit. From a former deputy who says he has 11 gigabytes of unuploaded bodycam video that directly contradicts Whitaker's sworn statements in at least 7 civil rights cases." Aisha exhaled slowly. "Then let's light the fuse." Monday, October 21st, 4 days after the stop, dawn had barely broken over Houston when the first process server walked through the glass doors of the Caldwell County Sheriff's Office. He was polite, almost apologetic, as he handed the receptionist a thick manila envelope stamped with the seal of the United States District Court for the Southern District of Texas. Inside, Montgomery vs. Whitaker et al. Civil Action Number 4:24 CV 03847 Plaintiff, the Honorable Aisha Montgomery. Defendants, Harlan Whitaker, individually and in his official capacity as Sheriff of Caldwell County, Texas, and 10 John/Jane Does, to be identified during discovery. The complaint ran 112 pages. It alleged 4th Amendment violation, unlawful seizure and attempted search, 14th Amendment equal protection violation, race-based policing, 1st Amendment retaliation, For Aisha identifying herself as a judge, Manel liability against the county for a long-standing pattern and practice of unconstitutional stops, searches, seizures, and evidence fabrication civil conspiracy under Section 1983 state law claims, false imprisonment, intentional infliction of emotional distress, abuse of process. Relief sought, compensatory damages in excess of $75,000, punitive damages in an amount sufficient to deter future misconduct, injunctive relief, including immediate suspension of Sheriff Whitaker pending independent investigation, attorney's fees and costs, and, buried on page 109 in subparagraph F, a single explosive line. Plaintiff reserves the right to seek certification of a class consisting of all individuals subjected to unconstitutional traffic stops, searches, or seizures by Caldwell County Sheriff's Office personnel from October 17, 2009, to the present. That one sentence turned a personal grievance into an existential threat to the entire department. By 10 a.m., the complaint was already uploaded to Pacer and being passed hand to hand among defense attorneys in Austin and San Antonio. Within 30 minutes, 3 separate insurance carriers who underwrote Caldwell County's liability policies received courtesy copies via email, along with a polite note from Maya Ellison. We intend to seek the full policy limits plus excess. Please assign counsel immediately. The county judge, the administrative head of county government, not a judicial officer, called an emergency closed session of the Commissioner's Court. The agenda item was listed simply as personnel/litigation matter. No one spoke above a whisper for 2 hours. Meanwhile, in San Antonio, Special Agent Carla Reyes of the FBI's Public Corruption Squad received the green light from her supervisor to open a parallel criminal investigation. Reyes had already read the viral video transcript and the viral X thread. She had also received an anonymous envelope at the field office the previous Friday, postmarked Luling, Texas, no return address, containing a single flash drive labeled R.C. Alvarez, BCC footage 2012 to 2017. She plugged it in on a clean, air-gapped machine. The first file she opened was dated July 14, 2015. Video showed Deputy Ramon Alvarez conducting a traffic stop on a Hispanic teenager for failure to maintain lane. The stop was clean until Sheriff Whitaker's personal cruiser pulled up 10 minutes later. Whitaker could be heard on the audio, body cam still rolling. Ramon, step over here. I'll finish this one. The camera caught Whitaker leaning into the kid's window, then, very clearly, slipping something small and white from his own pocket into the center console while the teenager's head was turned. Moments later, Whitaker discovered a baggie of methamphetamine during the search. The teenager went to prison for 3 years. Ramon's body cam captured the entire sequence. Whitaker never knew it was still recording. Agent Reyes closed the video, exhaled, and said to her partner, "This isn't one bad stop. This is a factory." By Tuesday afternoon, a team of 6 FBI agents and 2 DOJ prosecutors arrived unannounced at the Caldwell County Sheriff's Office with grand jury subpoenas. They seized every server hard drive, all body cam docking stations and memory cards, paper copies of every traffic stop report from 2015 forward, Sheriff Whitaker's personal cell phone, and 2 locked iPads, the department's cloud backup credentials, which Whitaker had reluctantly provided under threat of obstruction charges. Whitaker wasn't arrested yet, but he was placed on administrative leave by the county judge at the request of the Texas Rangers, who had been quietly looped in by the DOJ. A temporary replacement sheriff, a no-nonsense former Texas DPS captain, was sworn in within hours. The local paper, the Caldwell County Register, ran a front-page headline that afternoon. Sheriff Whitaker suspended amid federal probe. Federal judge's lawsuit sparks multi-agency investigation below the fold. A sidebar with a photo of Aisha Montgomery leaving the federal courthouse after a routine hearing in an unrelated case. The caption read, "Judge Montgomery declined comment, but sources say the $100 million figure being discussed in legal circles is not hyperbole." That night, Aisha sat in her home office, reviewing the latest filing, an emergency motion for a temporary restraining order to prevent any deletion, alteration, or transfer of department records. Maya had attached an affidavit from Ramon Alvarez, now cooperating fully under a proffer agreement with the DOJ. In it, Ramon described a system he called the envelope game. Whenever deputies made a stop involving cash amounts over $2,000, Whitaker would sometimes appear on scene, take possession of the seized currency for evidence processing, and later return only a portion to the evidence locker. The difference allegedly went into plain manila envelopes that were distributed to loyal deputies at the end of each quarter. Ramon estimated the total skimmed cash between 2012 and 2017 at north of $1.8 million. Aisha closed the laptop and stared out the window at the Houston skyline. She had wanted justice for herself. Now she was about to become the unwilling architect of the largest civil forfeiture and civil rights reckoning in Central Texas history. And the numbers were starting to climb. Fast. The first deposition was scheduled for November 12th in a windowless conference room on the 34th floor of a gleaming Houston skyscraper, one of those neutral ground law firm spaces rented by the hour for exactly this kind of bloodletting. Sheriff Harlan Whitaker arrived 15 minutes early, wearing his best Navy suit, the one usually reserved for re-election fundraisers, a fresh haircut, and the expression of a man who still believed he could talk his way out of this. Flanking him were two county-hired defense attorneys from a big Austin firm that specialized in defending government entities against overzealous plaintiffs. They carried matching leather portfolios and the quiet confidence of people who had never lost a Manel case, yet. Aisha Montgomery did not attend in person. Maya Ellison handled the questioning, flanked by two associates and a paralegal running the video feed. The feed was being live monitored by the DOJ prosecutors and FBI agent Reyes in separate secure locations. Everyone wanted to see how Whitaker would hold up under oath. The questioning began politely. Maya, Sheriff Whitaker, can you please state for the record the training you received regarding pretextual traffic stops after the 2016 Supreme Court decision in Wren v. United States? Whitaker shifted. We follow department policy. Policy says reasonable suspicion is required. Maya slid a single sheet across the table, Caldwell County Sheriff's Office General Order 2015-2007, signed by Whitaker himself. It read, in part, officers are encouraged to use minor traffic infractions as opportunities to investigate other criminal activity when reasonable suspicion exists. Maya, does encouraged mean required? Whitaker, no ma'am. Just encouraged. Maya, and on October 17, 2024, what was the reasonable suspicion that justified stopping Judge Montgomery's vehicle? A long pause. Whitaker glanced at his lawyers. One gave the tiniest head shake. Don't answer that one directly. I believe the vehicle might be involved in suspicious activity. Maya, what activity, specifically? Another pause. High-value vehicle in a rural area. Could be proceeds of crime. Or transporting contraband. Maya smiled the smile that had made cartel lieutenants crack on cross-examination. Sheriff, Judge Montgomery's vehicle is registered to her personally. Purchased new in 2022 with documented financing through J.P. Morgan Chase, payments current. You ran the plate before approaching the vehicle, correct? Yes. And the return came back clean? Yes. So the only articulable fact supporting your suspicion was the presence of a luxury sedan driven by a black woman on a highway you patrol? Whitaker's jaw tightened. I don't see color, ma'am. Maya didn't flinch. Then why did bodycam audio from at least 17 prior stops between 2019 and 2023 contain you or your deputies using racial epithets when discussing black and Hispanic drivers? After those stops concluded? The room went still. Whitaker's lead counsel objected, relevance. This deposition is noticed for the events of October 17, 2024. Maya, we're here under Rule 30(b)(6) for the county as well. Pattern and practice evidence is directly relevant to Manel liability. The videographer kept rolling. Whitaker's face had gone from flushed to ashen. By the third hour, he was sweating through his suit jacket. Maya methodically walked him through 7 specific incidents pulled from Ramon Alvarez's flash drive, each one showing Whitaker planting small amounts of narcotics or skimming cash during inventory. Whitaker denied everything. His denials grew shorter, angrier, less coherent. At 2:47 p.m., Maya played the July 14, 2015, video in open session. Whitaker watched himself slip the baggie into the teenager's console. His hands gripped the table edge so hard the knuckles blanched white. When the clip ended, Maya asked one question: "Sheriff, do you wish to invoke your Fifth Amendment right against self-incrimination at this time?" Whitaker looked at his lawyers. They were already packing folders. He muttered, barely audible, "I plead the Fifth." The deposition ended 8 minutes later. That evening, the second domino fell. A former dispatcher named Carla Mendez, who had quit in 2020 after Whitaker made an unwanted advance during a late shift, contacted Maya's office through a whistleblower hotline the firm had set up. She had kept personal notes and screenshots of text messages from deputies complaining about Hank's envelope nights. One message from 2018 read, "Another good quarter. My cut was $4,800. Tell the boys to keep quiet." Carla agreed to testify. She also turned over a thumb drive containing 6 years of dispatch logs that showed Whitaker routinely canceling body cam uploads for his own unit while requiring every other deputy to comply. By Thanksgiving week, the DOJ had impaneled a federal grand jury in Austin. Subpoenas went out to every current and former deputy who had worked under Whitaker since 2010. 12 accepted immunity deals within the first 10 days. 3 more were arrested on obstruction charges after deleting department emails the night the initial search warrant was executed. The money trail was uglier than anyone expected. Forensic accountants traced at least $2.4 million in unexplained cash deposits into accounts controlled by Whitaker, his wife, and 2 adult children between 2014 and 2023. Some deposits coincided suspiciously with large civil forfeiture seizures that never made it into county coffers. Other funds appeared to come from consulting fees paid by a private prison contractor that had been awarded lucrative transport contracts by Caldwell County during Whitaker's tenure. On December 3rd, the county commissioners voted 4-1 to settle Aisha's individual claims for $8.7 million, $2 million compensatory, $6 million punitive, and $700,000 in attorney's fees. It was the largest single payout in Caldwell County history. The vote came after the county's excess insurer threatened to drop coverage entirely if litigation continued. Aisha accepted the personal settlement on one condition: the county would fund an independent audit of every traffic stop and forfeiture case from 2009 forward, with results made public. Whitaker wasn't invited to the settlement conference. He had already been indicted the previous week on 16 felony counts: civil rights violations under color of law, Hobbs Act extortion, money laundering, conspiracy, witness tampering. He surrendered his badge the same afternoon the grand jury returned the indictment. His mugshot, still wearing the mustache, now graying, hit every major Texas news site within minutes. That night, Aisha stood on her balcony overlooking the city lights. Her phone buzzed with a text from Maya: "Class certification motion is fully briefed. We have 1,847 potential class members identified so far from the seized records. Estimated damages range $42 to $118 million. Aisha typed back one line: "Keep going." The fire she had lit was no longer hers to control. It was burning everything in its path. January 15, 2026, Federal Courthouse, Austin, Texas. The courtroom on the 7th floor smelled of old wood polish, fresh coffee, and nervous sweat. Judge Elena Vasquez, a no-nonsense appointee of the Obama era who had spent 20 years on the state bench before moving federal, presided over Montgomery versus Caldwell County, the now certified class action. After 9 months of ferocious motion practice, endless discovery battles, and 4 failed attempts by the county's new defense team to decertify the class, the case had finally reached trial. Not on liability. Liability had already been decided on summary judgment 6 weeks earlier. The dashcam video, Ramon Alvarez's testimony, the FBI seized bodycam footage, Carla Mendez's text message archive, and the forensic accounting report left no serious dispute. Caldwell County Sheriff's Office had engaged in a systemic pattern of unconstitutional traffic enforcement, racial profiling, illegal seizures, and civil forfeiture abuse for at least 15 years. The only question left for the jury was damages. 7 women and 5 men, 6 black, 4 Latino, 2 white, sat in the box, listening as Maya Ellison called witness after witness. A single mother from Bastrop whose $11,000 life savings were seized during a stop for a broken tail light in 2018. She never got the money back even after criminal charges were dropped. A truck driver from Luling who spent 14 months in county jail on planted methamphetamine evidence before the lab report was lost and the case dismissed. An elderly black couple pulled over 3 times in 18 months for failure to signal within 100 feet of an intersection that had no stop sign. Each time their modest savings envelopes were counted in front of them, then short when returned. By the end of the 3rd week, the jury had heard from 142 class members. The total documented economic loss, cash, vehicles, legal fees, lost wages, exceeded $18.6 million. Non-economic damages for humiliation, fear, and eroded trust in law enforcement were incalculable, but the plaintiff's expert, a nationally recognized forensic psychologist, testified that the average class member suffered PTSD-level trauma equivalent to victims of violent crime. Then came the punitive phase. Maya called one final witness, former Caldwell County Commissioner Roland Rusty Hargrove, subpoenaed under a grant of immunity. Hargrove, 71, walked to the stand with the slow gait of a man who knew his legacy was already ashes. Under questioning, he admitted the commissioner's court had received at least 9 formal complaints about Whitaker's traffic stop practices between 2012 and 2022. They had done nothing. Whitaker had personally donated $87,000 to commissioners' re-election campaigns during that period. Money that forensic accountants now trace to civil forfeiture proceeds never deposited into county accounts. In 2019, when the Texas DPS briefly opened an inquiry into Whitaker after a high-profile wrongful arrest lawsuit, the commissioners quietly lobbied the governor's office to have the investigation reprioritized. Emails recovered from county servers showed the county judge writing, "We need to keep Hank in place. He delivers." The courtroom was silent when Maya asked her last question. Commissioner Hargrove, looking back, "Do you believe the county protected Sheriff Whitaker because he was generating unreported revenue that indirectly benefited political campaigns?" Hargrove stared at his hands for a long moment. "Yes," he said quietly. "We did." Closing arguments lasted 2 days. Defense counsel begged the jury to consider the county's good faith efforts since Whitaker's suspension, new policies, body cam audits, independent oversight. They asked for restraint. Maya Ellison closed with 27 words. They didn't just violate one judge's rights. They violated an entire community's trust in justice for 15 years. The only number that matches the scale of that betrayal is the one written on the board behind me. She pointed to the whiteboard where the plaintiff's damages expert had written, in red marker, compensatory, $41,800,000 punitive, to deter and punish $58,200,000 total, $100 million. The jury deliberated for 17 hours over 3 days. On February 3, 2026, at 4:12 p.m., they returned. 4-person stood. "We the jury find that the defendants are liable for compensatory damages in the amount of $41,800,000 and punitive damages in the amount of $58,200,000. Total damages, $100 million. A collective breath left the gallery. Judge Vasquez polled the jury. All 12 affirmed. Across town, in a holding cell at the Federal Detention Center, Harlan Whitaker watched the verdict on a small wall-mounted television. He had already pleaded guilty to 11 of the 16 counts in his criminal case in exchange for a 22-year sentence. His wife had filed for divorce 2 months earlier. His children no longer answered his calls. He turned off the TV and sat on the edge of the bunk, staring at nothing. Back in Houston, Aisha Montgomery was in her chambers, preparing for the next day's sentencing hearing in an unrelated cartel case. Her phone lit up with a text from Maya, $100M. Exact. Jury didn't touch the number. They just wrote it. Aisha replied with a single emoji, fire. Then she opened a blank legal pad and wrote at the top, next steps, distribution plan for class members. Because the fight wasn't over. The money would be divided among 2,314 class members, the final certified number, with priority given to those who had suffered the most severe harm. Attorneys' fees, capped at 25% by court order, would still amount to $25 million. Most of which Maya's firm pledged to funnel into civil rights nonprofits and legal aid clinics across Central Texas. 2 weeks later, the Texas legislature quietly passed a bill banning sheriff-controlled civil forfeiture programs without judicial oversight. It was signed into law without fanfare. On the one-year anniversary of the traffic stop, Aisha drove the same rural highway in broad daylight. No sirens appeared. She pulled over anyway, voluntarily, at the exact spot where Whitaker had ordered her out of the car. She stepped onto the shoulder, looked around at the empty fields, the distant oil pumps nodding like metronomes, and whispered to no one in particular, "You picked the wrong Mercedes." Then she got back in, started the engine, and drove home. The road was hers again. And the story of one judge, one arrogant sheriff, and a $100 million reckoning became legend in every law school, every civil rights office, and every small-town sheriff's department in Texas. Some called it justice. Others called it a warning. February 18, 2027, Houston, Texas. The air in the newly opened Montgomery Civil Rights Center hummed with quiet purpose. Located in a renovated warehouse on the edge of downtown Houston, the center bore Aisha Montgomery's name not out of vanity, but necessity. It was funded by a $5 million endowment from her share of the settlement, money she had redirected from her personal award into scholarships, legal clinics, and community workshops on constitutional rights. The ribbon-cutting ceremony the previous week had drawn national media, civil rights icons, and even a few reformed law enforcement officials from across the state. Aisha stood at the podium in the main auditorium, addressing a group of 50 high school students from underserved neighborhoods. Her voice, steady and resonant as ever, carried the weight of experience. "Justice isn't a destination," she said, pausing to let the words sink in. "It's a road. Sometimes it's smooth. Other times, it's potholed with prejudice and power. But remember this, one stop, one moment of standing your ground, can change everything." The students nodded, some taking notes on their tablets. One young woman in the front row raised her hand. "Judge Montgomery, what happened to Sheriff Whitaker? Did he ever apologize?" Aisha smiled faintly, the kind of smile that hid deeper scars. "Apologies are rare in these stories, but accountability isn't. Mr. Whitaker is serving his sentence at a federal facility in Oklahoma. Last I heard, he's teaching basic literacy classes to other inmates, part of his plea agreement's restitution component. As for an apology, no. But the reforms his actions forced? Those are louder than words." She didn't mention the letters. The ones Whitaker had sent from prison, 3 in total, each more rambling than the last. The first denied everything. The second blamed the system. The third, received just last month, contained 4 words, "I was wrong." Forgive? Aisha had filed them away in a drawer labeled Evidence, Closed Cases. Forgiveness was her choice, not his demand. Across the state in Caldwell County, the changes were tangible. The new sheriff, Elena Ramirez, a Latina veteran of the Texas Rangers, had overhauled the department from top to bottom. Mandatory de-escalation training. Independent civilian review boards. A forfeiture fund that now funneled seized assets directly into community programs, not personal pockets. Traffic stops were down 62% in the first year post-verdict, and civil rights complaints had plummeted to near zero. But not everyone celebrated. In smoky backrooms of Austin bars, a few old guard politicians whispered about activist judges and overreach. One even tried to introduce a bill limiting judicial immunity in civil suits, framed as accountability reform. It died in committee, buried under a mountain of public testimony from class members who had finally found their voices. Ramon Alvarez, the retired deputy whose flash drive had cracked the case wide open, now worked as a consultant for the Montgomery Center. He led workshops for law enforcement on ethical policing, his sessions always starting with the same slide, a still frame from his 2015 bodycam video, Whitaker's hand mid-plant. "I kept quiet too long," he'd tell the room. "Don't make my mistake. Silence is complicity." Maya Ellison, Aisha's bulldog attorney, had parlayed the win into a national practice. Her firm now handled similar cases in Georgia, Ohio, and California. The $25 million in fees? Half went to pro bono work, the other half to expanding her team of young, hungry lawyers, many of them women of color mentored personally by Maya. As for the class members, their stories varied. The single mother from Bastrop used her $47,000 share to buy a home and start a catering business. The truck driver, exonerated and compensated $1.2 million, became a truck safety advocate, testifying before Congress on wrongful convictions. The elderly couple? They donated most of their award to their church, keeping just enough for a long overdue vacation to Hawaii. Not all endings were tidy. Some class members struggled with the trauma, seeking therapy funded by the settlement's mental health allocation. Others faced backlash from neighbors who still viewed Whitaker as a local hero. But the $100 million, distributed over 18 months, had ripple effects: scholarships funded, businesses launched, homes repaired. It wasn't just money, it was restitution. On a quiet evening in Port Harcourt, Nigeria, half a world away, a young law student named I scrolled through X on his phone. His handle, @IZCrypto, usually focused on blockchain and finance, but tonight he stumbled on a thread about the Montgomery case. The story resonated: corruption, resilience, a system forced to bend. He retweeted the original viral video with a caption, "From Texas to the world, one traffic stop, one judge, $100 million justice. What's your story of fighting back?" #accountability replies poured in, stories from Lagos, Johannesburg, even rural Texas holdouts. The thread went viral, amassing 200,000 views overnight. Back in Houston, Aisha saw the retweet during her morning coffee scroll. She didn't know eyes, but she liked the post anyway. Echoes, she thought. They travel far. The Texas traffic stop that backfired hadn't just ended a sheriff's reign or filled bank accounts. It had sparked conversations, inspired reforms, and reminded a weary world that sometimes the prey turns predator. And in the end, justice, slow, imperfect, relentless, drives on.